Hello, everyone, and welcome back to the Rebuttal podcast, where we break down case law, calamity, and of course, chaos in the legal field. I am once again your host, Reb Maisel, and today we are going to go through a case that, although the topic of it isn't funny, right, a very serious problem in this country, this beautiful US of A of ours, the facts are silly. To me, the facts are silly. To me, it's very unserious. It's very unserious. Look, if we can't giggle, we can't live. I am also going to start off this episode warning you that it is going to be a shorter episode, okay? I adore my very, very tangent-filled, hilarity-filled, info-filled, research, rabbit hole dive-filled episodes that are an hour and a half, an hour, 45 minutes, 2 hours long. But I also have been getting screams from you guys from the cheap seats and from the VIP sections that you want more. More. You are like these seagulls from Finding Nemo, mine, more. And I'm obsessed. I love it. Love you guys so much. And I totally get it. And I totally understand. So this is going to be the start of something new where I'm going to be reading through a bunch of cases that I think are fucking funny, fucking hilarious, as I always do, okay? As we always do on this show. Gonna be no different for sure. But every single little twig and branch of research that I could possibly go down may not be, climbed, which is great. But I'm still going to stick with my big kahunas, as I love to call them, okay, my big kahuna episodes, hopefully about like once a month, because those are my bread and butter. I love those so much. But you will basically, what I'm warning you about is that you're going to be hearing my voice a lot more. If you are a long-time listener, short-time listener, anytime listener. So here we fucking go. But before you can really adequately understand the facts as it relates to the law, we're going to start with the law, okay? The relevant law. We are going to get into Section 1983 actions. Now, not the deep dive, okay? Not the deep dive. There will be an episode for that for sure. But this is the brief overview, okay? Section 1983 is a federal law that provides individuals with a cause of action against state and local officials who have violated their federal rights, okay? 1983 actions are often come up. You've probably heard about them in the context of excessive force cases against police, okay? In the context of, basically federal officials, often law enforcement agencies, absolutely depriving people of their rights in such a manner that they subsequently file a civil lawsuit. Okay, so Section 1983 is a civil, basically route vehicle for, in theory, for people to obtain a remedy as the injured party for the deprivation of their rights. Okay, that sounds all great and fine and dandy. Of course it does. Okay, of course. Doesn't that sound like a great idea? Yeah, it does. But unfortunately, okay, Section 1983 case law, all right, and its application and that procedure is so confusing and muddled. And the courts have, including the Supreme Court, has basically developed this kind of common law, meaning like judge-made law, where it is extremely difficult to actually prevail as the injured party under a Section 1983 claim against, for example, a law enforcement officer. In part because of how kind of confusing 1983 claims have been for the last decades, and also because of what we call qualified immunity, okay, which is something that law enforcement officers, certain state agents have, that can be a complete defense to a Section 1983 claim. Makes sense? Amazing. Let's keep going. The text of Section 1983 states that, quote, every person who, under color of any statute, ordinance, regulation, custom, or usage, subjects or causes to be subjected any citizen of the United States to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws shall be liable to the injured party. Shall. Meaning, yes, must be mandatory, okay? The Supreme Court has held that the very purpose of Section 1983 was to interpose the federal courts between the states and the people as guardians of the people's federal rights. But it has also held that Section 1983 is, quote, not itself a source of substantive rights, but merely provides a method for vindicating federal rights elsewhere conferred. Thus, to succeed in a Section 1983 action, a plaintiff must be able to show that federal law protects the alleged right that state or local officials violated. Unsurprisingly, there has been an extraordinary amount of litigation over which type of official action is cognizable in Section 1983 claims. The statute's text only provides a cause of action to redress violations of rights secured by the federal Constitution and laws. Now, without getting into all of the different types of Section 1983 claims that relate to things that we think of immediately, like police brutality and, just official misconduct, there is another area, okay, of Section 1983 claims that proceed on a malicious prosecution basis, okay? Malicious prosecution is, in all 50 states, recognized as a separate civil claim that you can bring, indeed, for, as it literally describes, being maliciously prosecuted, okay? With no probable cause, with actual malice on the part of the prosecutor, on the part of law enforcement, etc. It comes as no surprise that malicious prosecution has long been an actionable tort in the United States and that its creation predates America, okay? This is not a new concept, all right? We have always wanted to get our lick back against the police and prosecutors who have used their power to fuck you over, in layman's terms. Not to mention the enactment of federal statutes such as Section 1983. The elements of malicious prosecution have remained consistent over time. An action that is initiated or continued with malice is without probable cause and is terminated favorably to the defendant in the action. Despite this history, courts have struggled to determine whether malicious prosecution is a tort claim masquerading as constitutional law or a constitutional claim itself. So without getting into the legal mumbo jumbo about why this shit is so technical, okay, Section 1983 actions, okay, so this claim filed in civil court by somebody who claims they were maliciously prosecuted is proceeding on that Section 1983 claim on the basis that they have a federal constitutional right to not be maliciously prosecuted. Okay, does that make sense? So Section 1983 actions based on malicious prosecution have sparked disagreement over where, if anywhere, this cause of action fits within the Constitution. Because remember, if you are claiming you have a right to be free from malicious prosecution in order for the 1983 claim to survive inherently, then that right has to be found somewhere in federal law or the federal Constitution. This is because Section 1983 is merely a vehicle to vindicate constitutional rights that independently exist. And how do you define a right if you aren't sure it even exists? The right to be free from malicious prosecution has remained elusive despite decades of judicial and scholarly attention. Some still debate whether it even exists, and many more argue that it should not. The constitutional malicious prosecution claim, often brought under Section 1983, is something of an enigma. Despite the name, the claims generally are not brought against prosecutors, and they rarely involve malice in an ordinary sense. Rather, they are part of the family of constitutional torts aimed at addressing police misconduct. Here, okay, in general, for initiating criminal prosecutions without probable cause. So, aimless, mindless arrests or indictments that just lead to the dropping of all charges, but nonetheless result in severe injury when there was no basis, no probable cause to do such a thing, okay, against somebody. Because again, this is why I scream from the rooftops that just because someone's been arrested, just because someone's been charged, I mean, yes, in our system, innocent until proven guilty, but you guys don't understand. I mean, some of you might, law students and lawyers, you get it, love you. But so many people don't understand that no, literally, the police can arrest you for nothing. In that moment, right, they can arrest you even if it's wrong. Even in that moment, even if you know for sure that it's wrong, even if absolutely they're going to have to release you because they can't hold you on any charges. It's the same thing as, when you get thrown in the drunk tank for a night, right? And then released without any charges. Were you charged with anything? Could you have been charged with anything? Maybe drunk and disorderly, right? Like maybe something like that, public intoxication, maybe open container, but you aren't charged, right? You aren't charged. Being arrested means nothing to me. Like that, it's so willy-nilly, especially because police officers are able to make, the way that our system is, these really shitball judgment calls that err on the side of just booking someone with and you know, claiming, oh yeah, I thought I had problem, they don't have problem, okay, yeah, they're released, whatever, without any redress, because they hide behind qualified immunity and they hide behind you know, oh well, you know, they're not going to do anything about it. They can't do anything about it. Okay, so that is where most of the malicious prosecution case law comes from, is people trying to get redress from being wrongfully, maliciously prosecuted, okay, quote unquote, by law enforcement officers, investigators who arrest them, book them, there was a fly, grand jury indict them, and really it's you know, later found out, yeah, no basis at all, literally no probable cause, which is required under the Constitution for them to have, okay, in order to do all of those things. At the very least, like, just because you haven't been proven guilty, right? Like, of course, right, innocent until proven guilty. They have not proven beyond a reasonable doubt until the you know, fat lady sings at the end of a jury trial, you know, that you are indeed guilty. But in order to even do any of that, there has to at least be probable cause, right? Amazing. So you understand why this gets hairy, because of course, unfortunately, our court system is so pro-police, has been so pro-police, and you can see where this is going, okay? You can see kind of where the issue comes about, because the court has a very low tolerance and a very queasy stomach about wanting to essentially make it a little bit easier to hold police officers accountable. And the rationale behind that, I think, has become so obsolete that we need to just do away with it, because the harm that comes from police misconduct, malicious prosecution, and police brutality is so far outweighing at this point, but it has for decades, any sort of con or risk that could come from police officers being, oh, you know, they're just sued for everything. Well, no, like, that's not how this would ever work, okay? But like, they need to be able to be sued for something. That's for fucking sure, okay? Be serious. Even people who are, oh, my dad's a cop, whoever's a cop, is a cop. The cops who do their fucking job, the same way that, right, I'm a lawyer. You could sue me for malpractice over some shit that was not my fault. That was not maybe a huge mistake, oversight, complete accident, whatever, and that would be right. You have that claim. You have that right, because we should be held accountable. Every other specialized profession, technical profession that could potentially end in the life or death of a patient, of a client, of a customer, etc. Doctors, surgeons, lawyers, therapists, all of that. You have grounds to sue them. Yes, there are so many things that indeed like protect us from being subject to random claims all the time. Like, we can't even move without being sued. But like, we are able to discern the fact that yes, there's a risk. Don't fuck around or you're going to find out. And police officers are that fucking exception in our society where they can fuck around and they have not once found out. Not un time. And it needs to stop. But I'll get off my soapbox. We'll continue. 30-minute episode. Are we going to do it? Maybe, maybe not. Oh God. And regardless of how important these lawsuits are in theory, because they are extremely important, okay, to maintaining and protecting the rights that we hold in our society, providing people who hold these rights, you and me, everybody in the US right now who stands on our soil, they have these rights no matter what, okay? These are so important for protecting those rights, to provide these people redress when those rights are violated. Despite how important they are in theory, in practice, these suits rarely succeed. Despite significant debate over the proper constitutional home of malicious prosecution, there is little clarity on its practicalities. After 30 years of effort, a, quote, embarrassing diversity of judicial opinion remains. So courts are split, courts don't know how to handle it, and in the context of Section 1983, okay, which is a federal statute, like suing under federal civil statute, I mean, the amount of people who have been unable to get the redress that they are absolutely entitled because of essentially this big progeny of law that's just a big shrug over, well, technically, actually, it needs to be based upon a constitutional right, and there isn't really technically a constitutional right to be free from malicious prosecution. Like, we need to have like done something, okay, about this. And absolutely it is possible for the federal government to have passed a statute. Okay, they passed Section 1983 to have passed a statute to remedy this, or pass a statute that provides people the right to be free from malicious prosecution, and stop, full stop, because then it would have taken away all of this debate, truly, because that's the right that you're conferring upon people from a federal law, which is Section 1983 says, hey, that if it's a right, federal law, federal constitution, yes, you can sue under Section 1983 about it. Yeah, they haven't. I love when people don't do their jobs. It's my favorite thing. So now that you understand Section 1983 to the very, very like scratching, not even scratching the surface, like literally like barely a hair on the surface, a whisker on the edge of what Section 1983 is, and malicious prosecution, okay, what that is, we are going to get into this fucking case, okay, because it is a malicious prosecution case. And you know what, my boy Kevin Albright, you really got gypped. You really got gypped with this, and it's extremely unserious. Of course it is, okay? Of course it is. The events of this case take place primarily in 1987, all right? The Supreme Court opinion that would eventually be issued on the lawsuit that Kevin Albright filed would be dated 1994, okay? The Court of Appeals opinion that I'm reading from right now is from 1992 because the Supreme Court doesn't get into the facts as much as the Court of Appeal does. God bless the Court of Appeal for doing this because we would not have known the tomfoolery going on. The plaintiff is Kevin Albright. The defendants are Roger Oliver, a police detective employed by the city of Macomb, Illinois, the home of Western Illinois University, and the city itself. In March 1987, Oliver hired a cocaine addict, Veda Moore, as an informant. She had come to him seeking protection from a drug dealer who was threatening her because she owed him money. Oliver insisted that she work for him as an undercover informant in exchange for which he promised her his protection and some pay. Her job for Oliver was to buy cocaine and report the sellers to him. She used the money that he paid her for this information to buy cocaine for her own consumption. She used the money that he paid her for this information to buy cocaine for her own consumption, and Oliver knew that. So like right here off the bat, okay, I understand the very intricate, complex world of police informants, right? Okay, and how snitches, okay, help put people behind busies, behind bars. But I fail to see the overarching public positive impact of using this woman specifically. Not necessarily because, you know, hey, like I'm not talking shit about addicts. It is a disease as opposed to something that you very much choose to do and choose to be. No one would want to choose to be that. And if you ask any of them, they would say, yeah, no, it's hell. But like, where is this protection, right, that you allegedly offered her? Like, where is the line between giving a shit about the health and safety of regular people and just exploiting them? This feels exploitive, right? Because she's using the government money, the Govy money, our taxpayer dollars to buy cocaine, which like, look, all right, the federal government pays so much. We don't know what the numbers are, but I could probably ballpark it. Probably in the millies or billies every year in essentially paying for illicit things, okay? Or bribing people. Maybe that's a conspiracy theory, fine. But like I remember in Zero Dark 30, the movie, okay, they claimed in the movie that, you know, the CIA, like the federal government, bought some guy a Lamborghini, like several luxury cars for information on Osama. And the CIA came out after the movie and said, oh, you know, a lot of it's accurate, but like we didn't buy anyone a Lamborghini. They fucking bought somebody a Lamborghini. Like they fucking did that shit. You know what I mean? Like, come on. Like, yeah, they fucking did. Like you're telling me, oh, they're like, they're holding tight to their moral scruples. They don't do that. They don't hold tight to much. Okay. So to think like on a large scale, I feel like it's easier for us to be like, yeah, they fucking did that shit. Like it wouldn't surprise you or me or the tree if they're like, well, we're trying to take down, you know, terrorists, like a main, you know, with literally number one FBI's most audit. Like, of course, we're going to pay for that kind of shit. And I think the public can stomach that. But on a very, very much, on a much lower scale, I think people don't want to believe that like these types of things are going on, but they are. Like they are. And you know, Veda Moore, okay? Maybe you would think, oh, well, she's doing so much for the good of the community, and she's really helping the police out. Well, unfortunately, if I were in the police informant draft, if I were a coach, if I owned a team, all right, of police informants of a bunch of snitches, and I wanted to throw in, all right, my draft pick, she would not be number 1. She would not even be top 10. She wouldn't even be first round. She would be 4th round if someone tore their ACL 3 times. I'm gonna be serious. She was a paid informant whose, quote, false accusations led to aborted and dismissed prosecutions on more than 50 occasions. 50. This woman, Veda Moore. She was not great at her job. She was paid for it with taxpayer dollars, and she used that money to buy cocaine. Queen. It's not queen. I'm not saying this is good, but I'm saying like she's a swindler. Like she's a fucking swindler. And I mean, fuck, you know, on more than 50 occasions, you'd think her name would get out there. You'd think people would be like, maybe I'm not going to sell to you anymore. Her only fucking job was just to buy cocaine and be like, that guy fucking sold me cocaine. Okay? So that is where our story begins. I'm already like, be serious, okay? Be way more serious than we are. So, in June of 1987, she reported having bought cocaine from a man named John Albright Jr. at a hotel room in Macomb, Illinois. She turned over the, quote, cocaine to police officer Oliver, and it turned out to be baking soda. Basically, I mean, how many other times had this chick like given them baking soda, been like, definitely Coke, and they're like, oh, we don't need to test it. I don't know, but it was 1987, so who fucking knows, okay? Maybe they samply-damplied it. Who knows? Without further investigation, because of course not, Officer Oliver testified about the transaction before a state grand jury, which returned an indictment against John Albright Jr. for sale of a, quote, look-alike substance in violation of an Illinois statute. So essentially, there was a statute that made it illegal to sell something that was a look-alike to an illegal drug, claiming that it is, okay? Oliver then went to John Albright Jr.'s home to arrest him, but found that Albright was an elderly, respectable, inoffensive gentleman, unlikely to have committed the offense of which Veda Moore had accused him. So, Oliver, okay, Officer Oliver, basically walked up to this door, like pounding on it, cuffs out, and this very elderly, like I'm imagining the guy from Up, okay, man opening the door going, afternoon. And he's like about to throw him down for cocaine charges. And he's like, hey, what's the problem? And in that moment, okay, the officer did use some common sense and was like, maybe this is a bunch of bullshit. Okay. But in that moment, you see, okay, look me dead in the eyes, police officers, in that moment, you do not have the ability to erase a name on a warrant, on an indictment, okay, that was already handed down by a grand jury for the arrest of this person, this old fucking man who you've never even apparently seen in person because how did you not even further investigate this? You don't even know what he fucking looked like? Like you're joking, okay? You got an indictment for him for cocaine charges and you didn't even pull up to his house and go, hey, what are the vibes? Nope, he didn't, okay? We're basing it all on Veda Moore, who's currently on her 3rd line of the day and 50th botched informing to the police, okay? Why are we still using her? I'm sorry, she needs to be fired. Like, why aren't people need to be, I'm sorry. You need to be fired, girly. I love you so much. You should have been canned. But she wasn't. She wasn't. Why? Because the police, why would they? I don't know. They're just throwing people in the can to hit their quota. Who knows, okay? So you can't, when you pull up and see this person, ID, right? His little old man wallet, like shaking hand, going, yeah, that's me. You cannot suddenly decide to erase their name on an indictment handed down by a grand jury or a warrant, an arrest warrant, anything. Write in someone else's name and then, arrest somebody else on the same facts but different guy. Like you can't, once you've gone that far, like you can't just fudge the numbers because that means, no, you have to start over. You got to start over, my king and queens, okay? But this cop did not. He said, you know what? I've got a lot of shit to do today. Veda, all right, has more people that she wants to finger for coke because she wants coke. So she's going to keep accusing people who aren't, right? Because she's getting paid for all the 50 fucking people who all of the 50 different instances in which charges were dropped based on her informing because her informing sucked. She still got paid for all that. I'd keep doing it too. Shit, Veda, get your bag. Like, that's how whatever. That's how I feel. Okay, it's 1987. Let me live. Okay, I'm not encouraging people to this, but God, like, why would she have stopped? It's not her fault. That's for fucking sure. So Officer Oliver is standing there asking this very old up gentleman some questions, and in response to Oliver's question, hey, do you have any sons? Maybe. Many sons, all right, that maybe I should be looking for instead of you, that maybe, you know, our informant, okay, got wrong. Like, she gave this full government John Albright Jr. with the junior name as an informant. That's your last chance. You can't start throwing in some sons into this equation. Like no, okay, but no. He said, hey, do you have any sons that could maybe fit the description and the behavior that I'm talking about here? And because his dad is an op, Albright said, oh, maybe you're looking for my son, John David Albright. Okay, I'm John Albright Jr. John David Albright is not a junior. He's a John David. Go talk to him. So Oliver, with a pen and paper, altered the name on the arrest warrant, erase, scribble, scribble, to John David Albright, resting only on the comment from an old dad who you still were able to arrest under the warrant, but like Officer Oliver was like, the vibes are too wholesome here. He's not running. He's not slinging baking soda as cocaine in a motel in Macomb, Illinois. So give me a name. And his dad was like, for sure, my boy John David. John Jacob Jingleheimer Smith. This is what this feels like to me, okay? It's just a bunch of Tom fucking foolery. Clown shoes are on. They are on and they are jumping. They are running. They are jumping, okay? He erased the name on the arrest warrant. He altered it to John David Albright and went to arrest him on literally that basis, only to discover that he had been physically in Chicago at the time of the alleged offense, at the time that he allegedly sold baking soda, passing as cocaine to our girl Veda Moore, who was understandably probably pissed. Okay? So we got one son who's not going to have it. So what does our boy Officer Oliver do? He flips a U-turn, goes back to the dad's house and says, hey, my guy, tried you, too wholesome, tried your son, John David, okay, out of town. Do we have any others that you could recommend for this charge, for this indictment? And his dad said, well, I do have another son, Kevin. And the officer said, perfect, and left. Erased for a second time the name on the arrest warrant, all right, and filled in Kevin Albright, a senior at Western Illinois University, okay, which is in Macomb. Yay to those who are alumni, okay? Officer Oliver called Moore, Veda Moore, okay? He's like, hey, so let's try to rework this narrative here, this bullshit-ass narrative, and asked her whether the man from whom she had bought the baking soda might be Kevin Albright. She said it was him, all right. Literally, quote unquote, in this court of been. She said it was him, all right. It was him. That motherfucker. Like, she has no fucking idea. She lied. She lied like a rug. Okay? She lied like a flea on a dog on a tree. She lied. But like queen shit for sticking to your guns, I guess. Okay? Ruining people's lives. She says, yeah, she bought the baking soda from Kevin for sure. It was him for sure. It was him all right. A criminal indictment was issued, charging Kevin Albright with the offense, followed by an arrest warrant. On this ground, that is it. I mean, you all know what my lesson is for this. This seems like the most obvious one. Shut the fuck up. Don't talk to the police. Who's your son? Don't fucking tell him a name. This is why you can't even tell them anything, okay? Nothing. Well, I just gave him the make and model of my car. Shut the fuck up. Shut it. Shut it. Zit. Do you have any sons? I'm not talking to you unless my lawyer's here. I'll tell you that. Slam. Do you have a warrant? Slam. he did have a warrant and totally could have arrested him, but he was like, never mind, I'm erasing your name. Do you have a name to fill it? Be like, nope, slam. God. Anywho, but he's an old man, and he's the old man from Up in my mind, in my head. So I'm giving him a pass this time. Like, it wasn't his fault. Okay, it wasn't his fault. He didn't mean to. Learning of the warrant, Kevin Albright, who's a senior in college, turned himself in. Was like, damn. Acknowledging to Officer Oliver, that he had been in Macomb on the day of the alleged offense, but denied any involvement in drug trafficking. Again, this is where you shut the fuck up. You should have when you turn yourself in, bring a lawyer with you. You don't say a word. Shut the fuck up. Stop talking to the police by yourself. I'm innocent. I don't need a lawyer. You're innocent. You do need one. That is when you need one. That is when you need one. The most. Everyone, guilty and innocent, needs one, but God damn it. The police are not paid to prove you innocent. Get it through your heads. As we always say, okay? Put it on a t-shirt. Thank you. He was booked and required to post bond. One mandatory condition of bond was that he not leave the state without the court's permission. At the preliminary hearing, held on January 5th, 1988, Oliver testified about Veda. My shit is so like untied, by the way. Oh, my shirt just went untied. If you're watching on YouTube right now, that's great. No, it's not. If anyone's sprinting over there to like try to like catch a nip slip, sorry. You're going to have to check back next time, but we're good now. Okay. At the preliminary hearing held on January 5th, 1988, Oliver testified about Veda Moore's information without, however, revealing his initial efforts against the other two Albrights. So he lied. His initial, like, he didn't talk about the fact that he pulled up. Oh my God. He literally just said, yeah, Kevin. It was Kevin the whole time. And the judge found probable cause to make Kevin Albright stand trial because of the police lies by withholding information, right? They just withheld, he just said, like, the Officer Oliver just like withheld the information about the two prior, right, fuck up names that they tried to swing on this with just Veda's word against literally anyone else's. And that's how the system, this happens all the time. Okay, you guys, police leave shit out on purpose to try to achieve a means to an end, which makes no sense because, like, what is the end here? You know damn well this motherfucker did not sell baking soda to Veda Moore in a motel. Be serious. No other evidence. Amazing. Perfect. Right? Perfect. This is how a system should run. For sure. The judge found probable cause, okay, to make him stand trial. But on June 27th, before the trial could be held, the circuit court dismissed the indictment against Kevin Albright on the ground that it failed to state an offense under Illinois law. The court does not know why not. We have not been able to find a copy of the decision. They literally said that in the opinion. They're like, we have no idea why, but like it was dismissed. The prosecution had received media coverage, okay, because Albright was like, what the hell? Albright had missed a job interview in St. Louis. He says because of the prohibition against his leaving the state, although he did not request the court's permission to leave as he could have done under the terms of the bond. The present suit, okay, this lawsuit was brought 1 day short of 2 years after the dismissal of the prosecution. So there is indeed a statute of limitations, okay? You can't just bring this whenever. 2-year statute of limitations for bringing like a 1983 malicious prosecution lawsuit, all right? The complaint states, for sure, a plausible claim for false arrest. It is true that Kevin Albright was not arrested in the conventional sense he turned himself in, but it is enough that he was booked, that was a seizure of his person within the meaning of the Fourth Amendment. So we have that covered. And probably the arrest, quote unquote, lacked probable cause. Detective Oliver made no effort, zero effort, to corroborate Veda Moore's unsubstantiated accusation. A heap of baking soda was no corroboration. Quote unquote. A heap of baking soda was no corroboration. Her initial misidentification of the seller cast grave doubt on the accuracy of her information, no shit. And this was part of a pattern. Of 50 persons she reported to Oliver as trafficking in drugs, none was successfully prosecuted for any crime. 0 out of 50 RBI, okay? You're batting 0. 0.0, okay? 0 out of 50 fucking, that's your record. Wins and L's. And she's still on the payroll with taxpayer dollars from the state. I'm obsessed. And payroll money that's going straight to cocaine. I'm obsessed. It's just, right? Isn't this not funding? Is this not directly funding the cocaine trafficking that you're trying to combat? Because you're literally keeping the customers her, right? Veda's a custody. She's a custody. You're keeping them ready to pay money. This is crazy to me. I'm sorry. It's crazy, but here we are. In the case of Albright, Oliver should have suspected that Moore had bought cocaine either from she knew not whom or from someone she was afraid to snitch on. Remember that she had gone to work for Oliver in the first place because she was being threatened by a man to whom she owed money for previous purchases of cocaine, right? Duh. The court says this. Okay, the court's like, remember, all right? Why the fuck did we even think that she, like, right? She's in fear for her life. You should have given her the safety and stopped using her. That she had consumed it and replaced it with baking soda, and that she had then picked a name from the phone book at random. This is the court's theory. That she had... I'm not laughing. It's not funny, but it is fucking stupid. She bought cocaine from someone, snorted it all, replaced it with baking soda, and then picked a name from the phone book at random. This is the court's theory of how this informant informed, and the police bought it because they will buy anything. Anyways. The fact that she used her informant's reward to buy cocaine makes this hypothesis all the more plausible. An arrest is a serious business. To arrest a person on the scanty grounds that are alleged to be all that Oliver had to go on is shocking, needless to say. The limits of reasonable police conduct may well have been exceeded here, always assuming that the facts alleged in the complaint are true. But Kevin Albright filed his suit more than 2 years after his arrest, so his constitutional claim of false arrest was barred by the statute of limitations. He has therefore had to base this suit on the events after the arrest, that is, on the prosecution itself, which ended on June 27, 1988, when the charges against him were dropped, and which he characterizes as malicious prosecution, okay? Which is why I gave you that spiel in the beginning. He contends that malicious prosecution is, or at least in particular circumstances can be, a constitutional tort. And so essentially, that was the one claim that he could still bring within the statute of limitations, okay? Because the other ones, like, they were, the court basically gave him at least the lip service to say, yes, you've stated claims plausibly for like false arrest, etc., because they just wanted to like talk shit about the fact that the shit was crazy. But they were like, look, we can't, like, if you do not file it timely within the amount of time that you're allowed to under the law, then like we can't, like, that you can't prevail on that. The court notes that the medley of harms that a malicious prosecution inflicts when, as in this case, the defendant is exonerated before any punishment is imposed, indeed before he is even put on trial, is similar to that inflicted by defamation, which by impairing a person's reputation not only embarrasses and even outrages, but also undermines his ability to make favorable transactions, whether business or personal, thereby subjecting him to costs, pecuniary or non-pecuniary, pecuniary or non-pecuniary or both. It also puts him to the expense of bringing a suit for defamation to recover his good name. If the injuries that defamation imposes do not constitute a deprivation of liberty or property within the meaning of the Due Process Clause, then neither do the injuries that malicious prosecution imposes. And here, this lawsuit, okay, like I told you, malicious prosecution cases filed under like a Section 1983 theory, okay, have to be founded upon a separate federal constitutional or like federal law right that you got, okay, somewhere. So you're saying, oh, that was deprived from me. And here, Albright sued on a theory under Section 93 that he was maliciously prosecuted in violation of his 14th Amendment rights, which is like equal protection, and then some due process rights there, okay? So here, the Court of Appeal, okay, the lower court before the Supreme Court says, essentially, it's like long and winded and we don't care, 30 minutes. Let's see if we even make it. I don't think we have. We do not place, quote unquote, we do not place malicious prosecution in the class of trifling infringements of the right to be free from oppression by police officers, but in the absence of incarceration or other palpable consequences, we do not think it should be an actionable as a constitutional wrong. So the court basically just decides that they don't think that Albright has sufficiently stated a claim that can survive, like the pleading stage, period. So it dismisses it. Albright appeals to the Supreme Court, okay, and the Supreme Court takes the case. Albright here, okay, is asking the Supreme Court to recognize a substantive right under the Due Process Clause of the 14th Amendment to be free from criminal prosecution except upon probable cause. Okay, that's what he's asking for, which would allow for him to sue on a malicious prosecution theory under Section 1983 because it's granting him that right. Everyone, that right to be free from malicious prosecution except upon probable cause. And the Supreme Court in 1994 declines to do so. Okay, they say, no, we're not going to do that. So his claim is dismissed. And because he was already like 1 day before the statute of limitations that he would have gotten fucked on anyway, he couldn't refile because the statute of limitations had passed. So he got no remedy for this clusterfuck. Yeah, I know. And again, because this is the short episode, y'all. Okay, I'm not going to get super technical into it. The spark notes of this is that the Supreme Court ruled that Section 1983 relief for prosecution without probable cause, malicious prosecution, okay, is only valid if the prosecuted party claims Fourth Amendment pretrial rights violations, not 14th Amendment, which is what Albright claimed. And in civil court, when you're filing a civil lawsuit, you are bound by what your complaint says. And if he had fashioned his complaint in a way that alleged the violation of his Fourth Amendment rights, here the Supreme Court is implying that it could have survived, but they like decline to comment on whether it would have been meritorious if he had done that. But it was past the statute of limitations anyway, so they knew they were gonna be done with this. Like, wipe their hands clean of this, okay? In a 7-2 decision authored by Chief Justice William Rehnquist, the court reaffirmed its commitment not to extend substantive due process indefinitely and held that substantive due process does not guarantee non-interference by criminal investigations. And this ended up being a very controversial decision, as this law review article states, okay? Quote, history remembers Albright as a definitive statement of malicious prosecution's home in the Fourth Amendment. Okay, Supreme Court saying you got to sue under the Fourth Amendment, kings and queens, if you want 1983 to apply. But a kick to its tires reveals that its holding is far less satisfying than the 3 decades of subsequent case law and scholarship suggest. The opinion found only that, quote, it is the Fourth Amendment and not substantive due process, the 14th Amendment, which Albright tried to sue under which petitioner Albright's claim must be judged. But it notably declined to adjudge, okay, Albright's claim under the Fourth Amendment or provide any opinion on the viability of such a claim. This narrow holding seems largely a product of skepticism towards substantive due process and did not leave a Fourth Amendment malicious prosecution claim much firm ground to stand on. And since 1994, okay, with Albright versus Oliver, there have been other cases where the Supreme Court has addressed Section 1983 and malicious prosecution, but none of them have been satisfying, okay, for either the legal scholars who follow these issues or the courts that have to apply these principles and laws in the context of Section 1983 claims. Obviously, because this is a short episode, we're not going to do the very, very heavy deep dive, but I'm going to do a deep dive episode on Section 1983 as it revolves around qualified immunity, which is absolutely grounds for an hour and a half fucking episode. God damn it. There's so much to cover there. Be ready to be angry when I post that episode. But in conclusion, okay, malicious prosecution claims, yes, can indeed survive. It's not that they can't survive. It's just that you have to fashion it very particularly. But they are difficult to prevail on, and they very rarely prevail on. In my opinion, I think they prevail too rarely. I think that they need to be more of a threat, honestly. It needs to be a risk for police to not do their jobs and to deprive people of their rights so blatantly. They need to be scared, and they're not. The point of these lawsuits is ultimately fundamental. If our right to be secure in our persons means anything at all, it's that we should be able to trust that this kind of thing won't happen to us. Such a right cannot exist without a functional remedy. Period. My rebuttal for today's episode is that if you are going to inform on somebody for selling you cocaine, maybe do not test the product first and fill the baggie back up with baking soda prior to informing on the name, and then also maybe get the name right, and then also maybe don't use the money for more coke that you get, the money that you get for being an informant for more cocaine. But who am I, right? Whomst am I? Whomst the fuck am I? But if it was working for her and the police did nothing about it, even though they should have known after 50 fails she was still going to be paid, then who am I to blame her, right? I'm not going to blame her. I'm going to blame all of the police involved. Love you guys. Thank you for joining today. See you next time. Be safe. Don't do cocaine. If you do not talk to the police ever. Love you.